say the unredacted 911 call, which we mark as 390?
Yes, either in whole or in part. I haven't yet decided depending on my process.
Mr. Martinez.
What I said in that 911 tape is irrelevant to how she is feeling after the call was made after the aggravated assault on her son. Initially, 414, 403, casting aspersions upon the victim's character are irrelevant to her, or irrelevant to this proceeding as to whether or not she is affected emotionally by the fact that the defendant committed this aggravated assault. So whether that not be allowed, that she not be allowed to be questioned.
Well, since there's been reference already made to her call, I think the jury should hear all the circumstances of the call, so the objection to claim 390 is over. Anything else for now, Mr. Maris?
No.
Mr. Martinez?
No.
Mr. Maris, tell me when you're set up and we'll bring in jurors.
Just 1 second.
Ms. Fernandez, if you would come on back. Be seated. Records reflect the term of jurors. Mr. Maris is starting to stand on oath, now beginning cross-examination. Mr. Maris.
Thank you, John. Mrs. Fernandez.
remember what year it is.
For possession of marijuana.
Yes.
Your Honor, at this time, we'd like to play the unredacted 911 tape.
Exhibit 390.
Exhibit 390, I'm sorry.
Is this being offered as an exhibit or for demonstrative purpose?
It's being offered as for demonstrative purposes.
Okay, ladies and gentlemen, the audio that's being played is going to be only in the courtroom. This is not something that we get in the courtroom.
Phoenix 911, where is your emergency?
My name's Elvira, and I was at the 303 East Carolina Avenue.
Can you say the address again, please?
Elvira Fernandez. I live at 303 South Mountain Avenue, State 51. My son has come home last night and he's a little white and then he's throwing things around the house and hurting my dog. And
He's throwing things now, ma'am?
yeah, you know, he's just so violent and it looks like he's going to hurt me. He's hurt me before.
Are you at the house now?
No, I'm at the neighbor's house.
And when was he doing this?
Just right now.
How long ago, ma'am?
So he's been maybe gone out and he's telling me he's cussing at me and he's got something stopping and so he threw something at me and he hit the wall and made a hole in the wall.
And how long ago was this, ma'am?
About 15 minutes ago.
Okay.
I hate to do this, but I can't. I'm just afraid to fear for my life.
How old is your son?
He's 29.
Okay. And is this an apartment complex?
No, it's a mobile home park.
Mobile home park?
It's called Casa de Francisco.
And you live in lot number 51?
Yes. It's one to leave and I'm just afraid that even if he's going to come back and hurt me. He hurt me before. I can't take it anymore, you know.
And how old is your son again?
29, his name is Daniel.
Daniel?
Yes.
And his last name?
Rodriguez. He leaves for 4 or 5 days and then he comes back off like it.
And is he white, black, Hispanic?
He's Hispanic.
How tall is he?
He's about 5'7".
And his weight?
About 160 maybe.
Color shirt?
And he's just in his room, that one in his clothes. I don't know, I haven't been in there.
Okay.
He just throws things out in his room and he hits the wall and he's big old dent and hole in the wall. Look at my house. How short, so wide.
Okay.
I just can't take it anymore.
And do you know what he threw out of the room?
I don't know, it was something sharp because it ripped me and it hit the wall on the floor. And so he quit throwing things and it scared the dog. The dog gets, I'm terrified and then I heard the dog crying in his room. I used to be real violent with my dog. He took finger all the time. The dog was a long time ago.
Are there any weapons in the house at all, ma'am?
I don't have any.
Okay, and you didn't see him with any guns or anything?
I haven't seen him. I don't know anything from him.
Okay. You haven't seen him with any guns or anything, ma'am?
No.
Okay. And are you going to wait there in lot number 50?
Yeah, I'm right next door to my house.
Okay, but you're at the neighbors in lot number 50?
Mm-hmm.
And you're going to wait there?
Yes.
And what's your last name, Elvira?
Fernandez. F-E-R-N-A-N-D-E-Z. I've called you guys before. I just want you to leave. I wish you would leave and not come back. But
Okay, is there anyone else in the house?
in my house?
Yeah.
No, just my sister's dog.
And has he been drinking or doing any drugs?
I don't know if he's been doing drugs, but he sure comes home like he has. I know there's none in the house.
And you have two dogs in the house?
Yeah, my dog's in my room and the other one's in his room.
Okay.
I've left her in there because she's got cancer, but you know, I didn't want her. But she gets so scared and I'm worried about it too.
Okay, ma'am. I'll send an officer to talk to you at 303 East South Mountain Avenue in lot number 50.
This is lot number 50? Okay, thank you.
And the name of the mobile home park again?
It's Casa de Francisco.
Casa de Francisco.
Mm-hmm.
All right, I'll ask an officer to come see you, ma'am.
Thank you.
You're welcome. Bye.
Record reflect that 390 was played, no questions were asked while it was played.
I have no further questions.
Mr. Martinez?
Ma'am, the fact that there may have been a prior felony conviction for marijuana back in whatever it was, 2005, 2006, does that take the hurt away just because there's a marijuana conviction?
No, sir, it doesn't.
Does it have anything to do with whether or not you feel guilty about calling the police and having this aggravated assault occur?
No, it doesn't just make me feel so. But I can't control myself.
You did mention in that telephone call that they just played for you just now, I just want him to leave and not come back. Do you remember hearing that?
Yes.
Make you feel any better?
No.
I don't know nothing else. Thank you.
And Ms. Hernandez stepped down, Mr. Martinez?
Yes.
Wait. Any objection, Mr. Mayor?
No.
Mr. Martinez?
Yes.
Any witnesses, Mr. Martinez?
No.
Mr. Martinez, you wish to proceed with a closing argument? You may proceed.
Sometimes there are things that you can say when somebody has expressed emotion to you. Sometimes there are things that you can say that perhaps help you identify with what is being said or the pain that you saw from the witness stand. And sometimes it's best just to let the evidence speak for itself. There's nothing that the state can add to what you just saw with Ms. Fernandez as that 911 tape was being played. Absolute guilt, absolute horrific feeling that she's the person responsible for Richard Chrisman coming over with that attitude again and taking that gun and placing it to her son's temple. She feels responsible for it. And how has she reacted to that? Well, at times, she has felt that she wanted to commit suicide. She wishes that she couldn't take that telephone back, as you saw yourself. So really, there are no words to add to her grief about the gun being pointed at her son's head. There really isn't much that anyone can tell you that you didn't see today about the emotional harm. There's extreme emotional harm that was caused in this particular case. She's his mother. She feels responsible for that gun being placed at his temple. One of the things that we can talk about, though, is this issue about somehow, because in 2005, 2006, there's this possession of marijuana conviction where she was convicted of a felony. Does that have anything to do with whether or not she feels emotional harm today? No. We can talk about that, and we can say that that was done to embarrass her. That was done so that when you look at her, she's not worthwhile to you. We can certainly stand up, but we can't really measure what she's saying in terms of her emotional distress. We can stand up and say, that has nothing to do with this, and it was only done to embarrass her. Because what does something that happened in 2005 or 2006 have to do with what happened in October 5th of 2010? Nothing. It's meant to divert your attention from her and embarrass her. Embarrass her even in these circumstances. And how about the 911 tape that was played? You think that playing of that tape takes away the pain from her? Or does it show you exactly how she is feeling and how much pain she has suffered? She is his mother. Even though he may have been this individual that was involved in ingesting methamphetamine 16 hours, 12 to 16 hours before this gun was placed to his head, even though that's the case, anguished about it. And she's clearly anguished and suffered emotional harm. There is a father that is also associated with this case, and he also has experienced emotional harm to the point that he has suffered 2 strokes from October 5th of 2010 until today. No one can say whether it's related or not. You know that there's emotional harm and there's medical issues involved with that are related to this case. At least that's what the evidence indicates. And so, really not much to say on behalf of the state other than take a look at that and look at the grief and look at the guilt, which is emotional harm. We could also say, take a look at what they tried to do to her on the witness stand, how they tried to embarrass her. But the person who has the last word in this case that we're talking about, seeing what can be said, is you. And I ask you to go back there, and in light of this performance, if you will, by them trying to embarrass her, go back and return your verdict. And your verdict being that there has been emotional harm caused to Elvira Hernandez and her family. Thank you.
Thank you. The instructions that you had before that we used during the last 4 or 5 days are also part of this case as far as the credibility of witnesses or witnesses. Only one witness. The credibility of that witness as to whether or not the emotional harm that she's expressed is related solely to the crime for which she convicted Mr. Chrisman, I think we should take into consideration. We certainly don't need to embarrass her at all, but we are.
Objection, well, that's what they meant. Hopefully.
Sure, it's raising your hand.
Can you see that I can't hear?
Yes?
Oh, certainly I can. Thank you.
Well, time out. Do you need anything repeated?
Yeah, go back.
And you did
Like
everything
2
right?
sentences back.
You did everything right. Tell us your number.
You're number 2.
All right, Mr. Burns. Why don't you say by the...
Oh, thank you. All right, thank you, ma'am. Ms. Martinez told you that we tried to embarrass her. We did not mean to embarrass her. You are the judge of the credibility of witnesses, and one of those things you can take into consideration is whether or not a witness has a felony conviction, and so that's why we put you on. Secondly, the instruction that you are not to be influenced by sympathy or prejudice is the same instruction that you must be guided by in your deliberations today. The issue here is whether or not, let me start again. Clearly, Ms. Hernandez was emotional on the stand, so for me to say that she wasn't emotional would be ridiculous. The question you have, though, is that emotional point that she was trying to make, is it related to the crime for which Mr. Chrisman was convicted, or does it deal with something else? Is it something other than that? Is it also overwhelming that it'd be difficult to separate it out? And I would suggest to you that it is. As it was in the previous case, it is the state's responsibility to prove the issue of emotional harm in this particular case and nothing else. So I would suggest to you that when she said, I keep thinking about that day, that she meant everything and not limited just to the assault that Mr. Chrisman is convicted of. And that therefore the state hasn't carried its burden to prove to you that it is that particular incident for which Mr. Chrisman stands before you now that causes all of this emotional harm. And I would suggest to you that the state has not carried their burden of proof as to that issue on this narrow issue. Thank you.
Martinez, any rebuttal?
The defendant, or defense counsel, anyway, told you that he did not mean to embarrass her. Well, one of the things that the jury instructions tell you is that you are to decide the case from the evidence. Evidence is what comes from the witness stand or through exhibits. Who took the witness stand on their side and said, we didn't mean to embarrass her? Anybody? Can anybody tell you that? Of course not. But yet they want to testify in front of you. They want to tell you, we didn't mean to do it. Well, if you didn't mean to do it, then why did you do it? Again, it was done just for no other purpose other than to embarrass. And they also said, well, this grief, as if they're all knowing again, because there's no evidence presented as to it. They said, well, no, this couldn't be separated from the killing. That's what they try to tell you. It's not the aggravated assault that she's suffering from. Why didn't they ask her that? They didn't ask her that at all. Yet they still want you to believe that. Here in this courtroom, you decide the case from what comes from the witness stand. As you have already been told, and the instructions tell you again, your decision is based on what comes from the witness stand, the evidence and the exhibits. The arguments or lawyers are just that. They are there to help you. In this case, they're not there to help you. They're arguments. They're there to hinder you because they're trying to introduce their own personal beliefs. Nothing that came from the witness stand.
Objection, Your Honor. You shouldn't even have that district. We had no obligation to present evidence.
Didn't he also say, though, he did not mean to embarrass? That's what he told you. That was not presented from the witness stand. And so I ask you to decide this case on the evidence that was presented here today. Of a woman who took the witness stand and told you that because of the aggravated assault on her son and the gun being pointed to his temple, that she suffered emotional harm, and so did her husband. She's part of the family. And given that, the state has proven this case beyond a reasonable doubt. There's nothing to contradict it. Thank you.
If we go to page 5, I'll finish up with the instructions. The only matter for you to consider is whether Mr. Rodriguez's family members suffered emotional harm as a result of the aggravated assault alleged in count 2. The case is now submitted to you for your decision. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinions if convinced it is erroneous. But do not surrender your honest conviction as to weight or the effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. If all 12 of you agree on a verdict, only the foreperson need sign it on the line marked foreperson. All of you must agree before you may find any aggravating circumstance proven beyond a reasonable doubt or not proven. The foreperson will be in charge during your deliberations and will sign a verdict form. You will be given one verdict form on which to indicate your decision. It reads as follows. It has been captioned, read the jury duly upon another sworn. In the above entire action, to the final oath, the matter to find beyond reasonable doubt upon aggravating circumstances checked below. The offense caused emotional harm to the victim's family. There's a place for proven. There's a place for not proven. There's a place for the foreperson to sign, print, and put your number. This time, jurors 1 and 16 will be redesignated as alternates to the remaining jurors who begin their deliberations. Mr. Foreman, if you advise us, we'll get you any exhibits that you may need to assist you. But at this time, the jurors may begin their deliberations. Is there anything for record?
Yes, Your Honor. I move for a misfile on behalf of Mr. Martinez, not having one for more than once. Should the attempted to shift the burden to the defense and say and tell the jury that we had
sustain the timely objection. I thought it was not over the line, very close to the line of burden shifting. Do not believe it's